Hi, CC students. I want to talk to you today about a topic that's a little bit different than the other topics involving the mock trial. And this topic is specifically about criminal procedure. And the reason we need to talk about this topic is we're getting some questions about the police and how the police do investigations, how this criminal process occurs. And I think it'd be helpful for you to have this basic framework understanding as you begin to go through the mock trial packet to understand what happens in a criminal case. So let's talk about criminal procedure basically. In any criminal case begins with an investigation, typically done by the police. And the police can investigate a crime from a variety of sources. They could get a tip from an individual. Someone could call 911 and say, "Police, I need help." And that's information they receive, and they begin their investigation. They respond to the scene, and they begin to do certain steps that we're going to talk about. The police may actually see a crime occur in their presence. They're driving down the road and they see somebody commit a crime. That's all part of the investigation. So it's the basic steps. They receive a call, they get a tip, they see a crime occur. Next step is the police arrive at where the crime has allegedly occurred, and they ask themselves two questions. Has a crime been committed, and who committed the crime? So whether or not a crime has been committed goes back to our types of trials for mock trial. Remember I said we have a criminal trial and a civil trial, and the criminal trial involves the violation of a statute or a law that prohibits certain behavior. So the first thing the police are going to do is they're going to say, did this behavior by someone, does that amount to a violation of the law? Is there some law passed by the legislature that prohibits this type of behavior? Okay, so that's the first question they're going to ask. So if it was a call about a murder, then they would go back and they would think in their mind, is there a law in the books that says murder is illegal? The next thing they would ask is, who committed the crime? Do we know who the suspect is? So their investigation would revolve around those two things. Has a crime been committed, and who committed the crime? Next step that they would do is they would begin to collect evidence. And the evidence that they would look for would be in the form of physical evidence. If it was a case involving a vehicle, maybe actually the vehicle itself, and we would begin to look at the vehicle to see if there's any physical evidence that relates back to the crime and also to the individual who committed the crime. Any documents that are related to the crime, maybe writings or papers, and also statements. And the statements can begin with the person calling the police asking for help, but it also can be a statement given by our suspect. So at the time that the police are doing their investigation, they may ask individuals questions before they arrest them. And those are statements given by an individual as part of the investigation process. This is all prior to the police actually arresting somebody. They ask, has a crime been committed, and do we know who committed the crime? Once the police have something called probable cause, and we believe, and probable cause means that it's more likely than not that this is what has occurred, right? The police believe that they have a person that crime has been committed, and that this is the correct individual. So they've developed probable cause. Now they move to arresting them. Hey, we believe that you did this violation of the law. We know that it's a violation of the law, so we're going to arrest you. Okay? At the time that a person is now placed under arrest, and what we mean by under arrest is actually physically taking away their freedom. They're placed in handcuffs. They are notified, you're under arrest. They're taken away from their home and placed in prison. They're in custody. We say they're in custody. At that point, we have something that involves Miranda, which was a Supreme Court case. And in your mock trial jury instructions, it talks about this. For a person who's now in custody, their statements cannot be used against them unless they've been given warnings that they don't have to answer questions. And the warnings have to be both understood and voluntary. Okay? So they have to understand it. Do they clearly understand the warnings that they've been given? And does the person voluntarily waive their right to not answer any questions and now answer questions by the police? Okay, so that's what Miranda is. The police would then move to, after they've arrested somebody, move to booking, and that's just a formal process of actually filing the paperwork against them. And then we have the charging, and this is really the formal part. Although they've been arrested, this is really where the formal part of the charges occurs. And this is important because we have some questions that have been coming about indictments, and I'm going to talk about that in another video. But the way that a charging occurs is in two ways. It can be either by a piece of paper called an information or an indictment. And what an indictment is the grand jury actually returning charges. What you need to know is they've actually been accused of the crime, and formal filing of the charges have been brought against them. That's this part of the criminal justice process. Formal charges have been brought against them. They are now charged with a crime. And that's where we are in this part of the process. Before we get to trial, we have pre-trial. And in your mock trial packet, there is indication that there's not pre-trial motions, but there is pre-trial stipulations. And what do we mean by that? Well, the pre-trial stipulations are certain facts. They're stipulated. They're agreed to facts that the parties are not going to disagree about. And you should look at those in your mock trial notebook so that you understand these are the pre-trial stipulations, whether it's statements by individuals or actual documents. They're going to be stipulated to. When we talk about evidence and when we talk about exhibits, we'll get into this more, but the authenticity of these documents are not in dispute. So pre-trial motions could involve us just agreeing with the other side that we're stipulating to certain exhibits. Now we're at pre-trial. The last step is trial, and that's where we are all in the mock trial process, is we move to trial. So before we get to our mock trial, we have these steps that are occurring in the background in any criminal case, and they're uniform. I think that you should discuss that with your classmates, especially as it relates to the witnesses in this mock trial, and begin to look at the witness statements and the evidence, especially the evidence collected by them, to begin to say what evidence has been collected by the police officer, what steps did they take, and how did they develop their probable cause, if your mock trial involves a criminal case, to show or to establish that it's more likely than not that this suspect committed the crime and the crime that they've been charged with. And I'll do another video about indictments because it's a little bit complicated, and I think it'll be helpful to go over that as well. Thank you, and I wish you best luck. Have a great weekend.